Hi, I'm Denise Bloch. I'm a healthcare regulatory attorney with Evans and Dixon. I'm officed in St. Louis. I have experience being in-house with large healthcare providers, term care, uh, post-acute, as well as one of the nation's, in the US's largest drugstore chains. But today we're going to talk a little bit about HIPAA and really in our COVID era. A little bit of what is HIPAA? HIPAA is the privacy rule impacting covered entities to protect the privacy and security of individual protected information, which is known as PHI. Covered entities and their business associates, as well as their subcontractors, are subject to the privacy rule, which really, it just says that they have to implement safeguards, only disclose minimum necessary, and don't need authorization to release information related to treatment, payment, and healthcare operations. There's also the security rule, or what we know as HITECH. And HITECH, it has to do with confidentiality, integrity, and availability of electronic PHI. That's that protected health information electronically. So those are the little bit of background, what we're talking about, say HIPAA. HIPAA has obligations to those covered entities relating to how patient information is shared, how patients are able to even access care. And during COVID, it's important to understand that HIPAA is remaining in force. There's some parts of HIPAA or some requirements which are maybe lessened right now, and I'll mention, we'll go through those. But the key thing is to remember HIPAA does continue to remain in force, and covered entities need to be aware of that. What they can disclose, as I said, are certain information without authorization from patients. Things like for treatment, public health activities, and that's really where we get into a lot of the disclosures right now, because we have things like the CDC, local public health agencies, which need to do patient contact tracking for those individuals who do test positive for HIPAA. Family and friends who are involved in patients' care also can oftentimes get PHI, but the real thing right now that we need to be thinking about, we want to lessen any serious or imminent threats to public health. We talk about, I mentioned minimum necessary. Whenever a covered entity, business associate, or their subcontractors, and I'm going to just refer to covered entities, but it includes those business associates and subcontractors. Whenever they're disclosing information, it should always be the minimum necessary. In other words, you don't want to be providing, your client shouldn't be giving out any more than is just minimally necessary to accomplish the task at hand. And it's real important also for those covered entities to make sure that the workforce who has access to protected health information remains limited only to minimum necessary. And there's training that they need to receive, so in restrictions that should be placed on them. Security safeguards relate to administrative, physical, and technical safeguards. Again, that's the HITECH side, the security side, and that remains in force through the COVID crisis. One of the, I guess I've mentioned what, covered entities, you should know that they're health plans, healthcare clearinghouses, and healthcare providers who conduct one or more transactions electronically. If you've got a doctor who's keeping everything on paper and never submitting a bill or a claim or a record into an electronic system, they're not subject to HIPAA. But that would be the very unusual provider in this day and age. The covered entities are and business associates. Those are the people who the covered entities share protected health information with, and those to perform functions on the covered entity's behalf. And that includes those people that the business associate subcontract to. So if they're creating, receiving, maintaining, or transmitting protected health information, they are in fact a business associate of the covered entity. Couple things that right now are lessening in terms of how much covered entities need to worry about HIPAA. There are some sanctions and penalties that have been relaxed, particularly related to the public health emergency. Sharing information, as long as those covered entities are sharing information with public health and have a good faith reliance on their need, they're not going to be subject to sanctions or penalties. There's also been waivers and relaxation of the standards for telehealth in terms of the kind of systems that telehealth can be using, the way information can be transmitted, and also the community testing sites for COVID, because the information may not be as tightly controlled as it would have otherwise been. So those are the things to keep in mind. And we should also be thinking forward. Once COVID's over, there are going to be some changes. And I think we need to be thinking about what's next. Right now, one thing that we are seeing, the OCR, who is the agency responsible for HIPAA enforcement, is still pretty active. And they have an initiative right now that patients should have access to their healthcare records. And in fact, have entered into 10 settlement agreements since they started this initiative last year. So, as I said, HIPAA is not going away, but we're going to see, I think, more expansion of telehealth and probably a lot more guidance, because the whole COVID crisis has allowed for a lot of expansion in terms of technology and the way health information is being transmitted. Anyone, if they have clients who have requests or needs related to protected health information, and to understand how HIPAA works. Thanks for listening, and I welcome your questions.